Hello, this is Matt on the Moon Lambeau channel. Today, Ripple's attorneys have drafted a letter and sent it to the judge, claiming that they don't have enough time to respond to the most recent SEC nonsense, which was filed on May 7th by the asshat army over at the SEC. And it's amazing to me. I sat here and as I saw this, and I was like, this is not me being critical. I'm just observing this, and I'm sitting there thinking, my gosh. Between Ripple and Ripple CEO Brad Garlinghouse and Chris Larson, who is Ripple's co-founder, between Ripple, Brad, and Chris, they have 21 lawyers that they've hired. And you know that there's got to be a team under them that are helping do various supportive tasks along the way too. And still, not enough time to file. And so this is not, again, I want to be clear, I'm not being critical. What I'm thinking here is that they must be drafting up one hell of a freaking response to what the SEC had to say on May 7th. So I look forward to seeing that. That's not the only thing I'm looking forward to, though. Attorney John Deaton. You know who John Deaton is. I bet just about 100% of you you do know. But there's always new people hopping in the XRP community, so I need to make sure you know. John Deaton, he's an attorney who is seeking to intervene in the SEC versus Ripple case. He has filed a court document. What's the right word here? There was a motion. Whatever. I'm not a lawyer. You got the cut of my jib. Damn it. He filed something, and we're waiting to hear back on a response from the judge ultimately. But John Deaton first will get to respond to the SEC because. Even though John was allowed to file, and it was also on behalf of about 17,000 XRP holders who are not too happy with the SEC, he filed this explanation why he feels that they, as a third party, we should be able to intervene because basically the SEC and Ripple not sufficiently in tune with the wants and wishes of XRP holders here. It makes a ton of sense to have XRP holders in as a third party. And the SEC doesn't want that. Ripple actually does want it. The SEC does not want it, which is kind of funny because the SEC is supposed to be protecting XRP investors. And so they articulated why. I covered it very thoroughly in a video. And now John is actually in the process of drafting up a response, which we're going to be seeing pretty soon. And I'm sure it will indeed be a blistering response because I'll tell you what. This guy knows how to put together a damn good argument. I've read everything that he has drafted on this topic, beginning with the writ of mandamus back in January. I've read everything that he's put out, and it's impressive. And the degree to which he clearly has a fire lit under him, it's very evident. So anyway, I think it's impressive. But I do want to be clear before I go further. I don't have a legal or financial background of any kind. I'm not offering legal or financial advice, and you should not buy or sell anything because of anything I say or write. I'm just an enthusiast making YouTube videos purely for fun all up on the internet. That's all that's happening here, just to be super duper clear. Now, here's a post from attorney James Filan, who is an XRP community member, but not part of Ripple, not part of the SEC either. And I shared this document, and this is what was filed today from Ripple's attorneys to Judge Sarah Netburn. And they wrote the following. It's very brief, but check this out. Dear Judge Netburn, we write on behalf of defendants Ripple Labs, Inc., Bradley Garlinghouse, and Christian Larson, collectively defendants, pursuant to Part 1G of the court's individual practices and the consent of the SEC to request that the deadline for defendants' response to the SEC's May 7th, 2021 letter be extended 2 business days from Wednesday, May 12th, 2021 to May 14th, 2021. Ordinarily, defendants' response would be due on Wednesday, May 12th, 2021. Defendants respectfully request an additional 2 business days to fully respond to the SEC's letter. This is defendants' first request for an extension. Defendants sought the SEC's consent by email on May 7th, 2021 and received it later that day. And so there you go. They went to the SEC first and said, hey, we do need a couple extra days to put together a proper response to you. And actually, to the SEC's credit, they said, thumbs up, yes, that's perfectly fine with us. But they also need permission from the court. So Judge Netburn would need to give this the thumbs up also. Given that there hasn't been a request for an extension, you'd kind of be surprised if the answer were no. Plus, if you want to make sure that things are done in as just a fashion as possible, Wouldn't you want this, especially that you're only talking about 2 business days? It's not going to throw out of whack the whole timeline for the trial and everything else, all the pre-trial hearings and everything. It's not going to put everything down the crapper effectively. It's going to be fine. So I guess I'd be surprised if this little request were ultimately denied. But again, I still go back to that thought. I'm like, what are you crafting, Ripple? I cannot wait to see this. And of course, as soon as it's put out, I'll be making a video that day on it. But I'm super duper curious. But it just, to me, you know what it shows? To me, it shows the degree to which Ripple really is being extremely, excruciatingly precise in what they're putting out, and just go into painstaking details, just make sure that they're uncovering what's under every single rock, and really crafting something that's extremely just thorough. So we shall see. But just as a quick reminder too, for those of you that don't recall or perhaps maybe missed it, this is what the SEC filed on May 7th. And it resulted in a bunch of headlines, including this story from You Today titled, SEC wants to force Ripple to testify about legal advice it obtained regarding XRP status. So it's on this topic, what I'm about to cover here, and I'll be brief since I did talk about this, but I want to make sure that you guys know. But this is what Ripple will be responding to. Anyway, discovery fights between the U.S. Securities and Exchange Commission and Ripple are heating up, with the SEC's senior trial attorney, Jorge Tenrero, filing a motion to compel the company to produce documents and testify about any legal advice it obtained regarding XRP status. The SEC asserts that the defendants received extensive advice regarding whether or not its sales would be subject to federal securities laws as early as 2012. It claims that Ripple has withheld at least 657 relevant documents dated between 2013 and 2018. The move appears to be aimed at enfeebling Ripple's key fair notice defense that the SEC is attempting to quash. And so this is very crucial. So the fair notice defense, it's basically Ripple's argument that, hey, and I'm paraphrasing here, just put it in a nutshell for you. Hey, XRP's been traded globally for the better part of a decade. You allowed this to go, the growth to occur unfettered. And now you've got hundreds of exchanges trading it, literally millions of people holding and trading it. And now after a decade, you want to come and say, after all of this damage has been done, that we should have known better. Well, there is such a thing as fair notice requirements. And Ripple certainly wasn't provided fair notice. And that's what they're saying. Now, the SEC says it's a nonsense argument. I do not agree with the SEC. That probably won't surprise you. I'm willing to bet you don't either, because it is nonsense. It's utter nonsense here. But here's a quote from the SEC. If lawyers told Ripple what the law says and how to comply, based on whatever facts Ripple disclosed to those lawyers, the fairness doctrine entitles the SEC to full discovery on the notice Ripple and its employees actually received. Now, it gets complicated, though. Let me pull up this. So, here's what John Deaton had to say on that topic. So this is, again, the attorney John Deaton, who is seeking to intervene in the SEC versus Ripple case. And I really hope it happens. No guarantee, but that would be fantastic. Anyway, here's what he said, though. The SEC just filed this letter asking for a conference on whether Ripple must turn over the legal memos it received in 2012 about XRP and how, if marketed and sold in a specific manner, XRP could be considered an unregistered security. Back in January, I tweeted that the due process / lack of fair notice defense had real teeth. So let me pause there. It is a legitimate defense. And I think it's clear the SEC knows that, and they don't even want Ripple to be able to use this defense in court. But it does have real teeth, just as John Deaton stated there. And then John continues. This proves that the SEC also considers the defense a real threat. Ripple has argued that the legal memos only show general advice that it's possible to utilize and sell XRP in a way that violates securities laws, but ultimately concludes that XRP itself isn't a security. Yeah, that's certainly true. And then in addition to that, just think about this idea of, like, if you are doing a risk assessment of something, in anything in life, and you hire an attorney and they come back and say, yeah, we think it's fine, but just so you know, somebody could perceive something in a way that we don't believe is in line with reality and bring charges against you. Does that mean that you do something wrong? Like, say you proceed with whatever venture it is that we're hypothetically talking about here. If you proceed with that, does that mean that you did something wrong because a lawyer you hired acknowledged that perhaps somebody could bring a bogus claim against you? Does that make logical sense? No, it don't make no damn sense to Moon Lambo. Bunch of asshats marching along that. Asshats marching. That's exactly what they sound like. You can hear them when they're coming down the street, man. It's annoying AF. That's anyway, John continues here. Whether the judge will compel Ripple to turn over the memos is an interesting legal issue. Ripple is only raising the defense because it was sued by the SEC, so I don't believe just because Ripple is using it for one of its defenses, the SEC gets the documents in their entirety. The stronger argument for the SEC is that if Ripple shared the information to third parties, like investors, they waived the privilege. Regardless, the SEC is definitely worried about this defense. No fooling. Now, you know what? Other than that, so moving on to the next legal topic here. You know what I'm most looking forward to? Because look, there's a list on your screen. Don't worry if you're driving or something, it doesn't matter. But it's a list created by attorney James Filan of upcoming due dates regarding the SEC versus Ripple case here. And Brad Garlinghouse and Chris Larson, of course, cited at the top of this thing. Out of all these dates cited here, there's one that I'm most looking forward to, and it occurs, where I'm circling, May 17th, 2021. And what is that? It's John Deaton's reply to the SEC's opposition to intervention and Ripple Labs' position on intervention. Also, the SEC's response to Ripple's position on intervention is due. And so, to be clear, and I cited it a few minutes ago, but just to make sure everybody recognize this before I go forward, Ripple does want John and he's representing 17,000 XRP holders, mind you. Ripple does want John to be able to intervene in the case, though in a limited capacity. The SEC does not want John to be represented. And so, you know, it's so funny too. One of my favorite things about that is that the SEC actually argued that John Deaton and the 17,000 XRP holders should not be able to intervene because their wants and wishes, however you want to word it, are sufficiently represented by Ripple. And so you listen to that and you might go, that's an interesting claim, because isn't it the case that you, the SEC, are supposed to be the ones that have the XRP holders' interests in mind? Isn't that kind of part of your mission statement? Yeah, it's literally in your mission statement. I pulled it up in previous videos. You're supposed to be looking out for the investor, but you say, no, Ripple's doing that. Well, it's not their job to do it, but they're definitely doing it more than you are. Freaking SEC, man. It's ridiculous. And so, so John's preparing to respond to that, you know, what Ripple had to say about, you know, hey, yes, we give the thumbs up. We want you to be able to intervene in some sort of limited capacity. And the SEC saying no. He's responding to that. He's crafting this thing right now. And so he actually shared a little preview. Now, in this case, feel free to take a look at your screen if you're not driving or something. If not, then I'll just kind of describe what's going on here. But there's a picture with a very messy desk with lots of papers. And John shared this, and he wrote the following. Someone asked me how the reply brief was going, so I figured I would keep you updated. This is what our reply brief looks like 1 week from deadline. In other words, right on schedule. And so here, I'll even pull it up full screen here. Like, this is looks like a tornado came through. And and look, I don't mean that in some sort of mean way, obviously. Like, he is he's hard at work, you know? And usually when you got stuff like this going on, there's usually some sort of method to what looks like madness anyway. But my gosh, there's so many documents. I can only imagine what it's like to put something like this together. And so, you know, we get the benefit, whether it's John Deaton or Ripple or anybody filing documentation that we get to neatly read. Like, we can only, like, we don't know the amount of sweat that went into putting that together, and how many eyes had to look over to make sure there isn't even a typo and all this stuff. And so he's in the process of putting all of this together, and it's a big freaking deal, because this case is the biggest case that the SEC has going on right now, and frankly, it's the biggest case that the SEC has brought, biggest non-fraud case at least that the SEC has brought in a matter of decades. I think that John Deaton has indicated that's his opinion as much too. I don't want to put words in his mouth, but I believe he's also indicated that as well. And so this is a big deal, and he is having an influence on this, and it is for the positive. If it weren't a positive thing, I'll tell you what, Ripple wouldn't want him to be able to intervene in any capacity. So this is good, and he's doing a bang-up job, and there's a reason that he's getting so much support from the XRP community, and it is well-deserved for sure. And then this was kind of funny, too. Somebody named Michael saw that picture on Twitter and wrote the following. "Someone get this man more Starburst." And I read that and I was like, what are they talking about? And then John Deaton saw it too, and he responded, "You guys are the best," with a little laughy emoji. And I was like, what's going on? So I looked at the picture again, and sure enough, there are a bunch of Starburst wrappers all over the damn place. But hey, you know what? Starbursts are delicious. They don't get enough credit. Probably because they're not chocolate, and chocolate is superior to any candy that is not chocolate. And that is fact. And if you don't like it, you can get out. There's science behind that, my friend. So maybe what we do, once this is all said and done, maybe we get the man a bunch of Starburst, if he'll accept it, because and I understand why. He's not accepting any sort of gifts, or because people, so many people so kind in the XRP community, they've offered to do all sorts of things for him. And he's like, no, it looks bad, this and that, so many reasons, there's ethical questions, whatever at play. And so he has to tonight, but I'm hoping once this is done, if we can at least get the man some freaking Starburst, all right? I'm just saying that would be the very least we could do. But I'll tell you what, if he'll allow it, I will get the man some Starburst, however many he wants. Back up the truck, man. And so it'll be interesting to see what ultimately happens here. But man, it's been quite the ride. I think we'll all agree on that, and it's been really exciting to see Ripple be supportive of all of this too, and I can't wait for this thing to be released publicly for him, to ultimately file this, and for us to get to see publicly exactly what's being drafted here. But the thing is, like, the SEC, they have to know that their arguments are piss poor and illogical, and that they're being hypocrites. And so it's like, given that John is just being like an intellectually honest human, my gosh. It's like, which side would you rather be on? And so as I read through everything that John writes, you can tell that there's the fire under him, and he's just acting within the realm of reality. And the SEC, because they want things that are not in line with reality, they just lie, right? And as I've cited so many instances on this channel here. And so as a result of all of this, it's just interesting watching John Deaton tear their crappy arguments apart. It is a true pleasure. So I'm looking forward to seeing just the degree to which he puts up a blistering response here, but that it's going to be coming. So we can look forward to that sooner than later. But I'll go ahead and wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.